What is a termination of parental rights (TPR) hearing in New Jersey?
In New Jersey, termination of parental rights means it severs your legal bond with your child and your legal right to any form of access or contact with your child. It is a very severe remedy, and it is reserved for the most severe of cases of child abuse and neglect. So typically, someone is not going to have an application filed by DCPP to terminate parental rights until there has been a substantial length of time of involvement with the agency of findings of child abuse and neglect. And the agency is required before filing, as in fact they have to plead in their filing of a complaint for guardianship, that they have actually provided you services and that those services have not remedied the issue. So typically you're going to have a long involvement with the agency before termination of parental rights happens. But if an application is filed and if the court, after taking testimony and having a trial, affording you the opportunity to defend yourself, finds by clear and convincing evidence that your parental rights should be terminated, that means that ultimately you will have no further right of access to your child and no court entitlement to do so. So that severs the legal parent-child relationship. That means you could not go back to court and request parenting time, even supervised. That means you would not have any rights of further contact with your child, no further responsibility for your child, so child support is also terminated, and ultimately inheritance rights would no longer pass from you to your child in the future. So it's very important that when the application, if an application for termination of parental rights is filed, that you consult with a DCPP attorney to ensure that you're doing everything that you can to prevent an order being granted by the court to terminate your parental rights.